Welcome back. Our next speaker will be Professor Gerry W. Beyer, who is the wonderful faculty advisor for the EPJ, and he will be speaking today on a case law update. Professor Beyer joined the faculty at Texas Tech University School of Law in June of 2005 as the first holder of the Governor Preston E. Smith Regents Professorship. He is the recipient of dozens of outstanding and distinguished faculty awards, including the Chancellor's Distinguished Teaching Award, the most prestigious university-wide teaching award at Texas Tech. In 2015, Professor Beyer was awarded the Accredited Estate Planners Distinguished Designation at the National Association of Estate Planners and Councils annual conference and was inducted into the Estate Planning Hall of Fame. Professor Beyer's Wills, Trusts, and Estates Prof blog is the #1 ranked estate planning blog in the U.S. For 5 straight years, it has been ranked in the ABA's Journal Blog 100 for best legal blogs selected by the ABA Journal's editors. In 2015, it was inducted into the ABA Blog 100 Hall of Fame. He has authored and co-authored numerous books and articles focusing on various aspects of estate planning, including a 2-volume treatise on Texas wills law, an estate planning casebook, and several editions of the Wills, Trusts, and Estates volume of the Examples and Explanations series. He has won awards from the American Bar Association's Probate and Property magazine for his writings 3 times and is one of the most downloaded law authors on the Social Science Research Network. Professor Beyer is further the editor-in-chief of the Real Estate Probate and Trust Law Reporter, the official publication of the Real Estate Probate and Trust Law section of the State Bar of Texas. He is a mentor to many students and various law organizations, but as I stated earlier, most importantly, he is the faculty advisor for the EPJ. Today, Professor Beyer will be providing a case law update, so please help me welcome him to the stage.
All right. Thank you very much. Thank you very much, Amanda. And I would be remiss if I didn't again congratulate the Estate Planning Journal for putting on this awesome seminar. So thank you to all of the EPJ members. And of course, I also thank all of you for your support in attending today. Now, you know I'm going to be talking about recent cases, and you know sometimes they're not as much fun as they could be. So instead, I'm going to start by telling you about 3 different areas of estate planning, some new things that are going on that you might be interested in. One of the newest additions to an estate plan is to create your final playlist. That is, the songs that you want to hear when you make that one-way trip from the living to the dead. You see, experts claim that hearing is the last sense to fail before death. So it certainly makes sense that you would want to enjoy what you hear right at the end. But the problem is, when the end is near, you probably cannot select your songs. So what you need to do while you're alive is put together the awesome mix, sort of Guardians of the Galaxy style, for your last playlist. Now, what would I want? I think going out on the last note of Stairway to Heaven, that would be the way to go. And then a few preludes like Don't Fear the Reaper, Tears in Heaven, and Fade to Black. Now, if some of you have lived an evil life, maybe you should just end with Highway to Hell. That'd be the way to let it go. Second new development. Now, how many here are either married or in a relationship? Right. Now, your partner knows you're here, right? They know you're here. But what if you were to go home early and in that bed you saw 4 wiggling feet? That wouldn't be very good. So, boy, some of you are awful quiet, like, maybe that's happening. Well, now there would be one way you could monitor this. You could have some secret cameras in there, and you could be watching your cell phone all the time. But that's a real pain. So instead, this company, it's the Dumais company, they have developed this special bed that has in it the lover detection system. And it has 24 sensors built into the bed. And then if it detects suspicious activity in the bed, it'll alert on your phone. It'll go off and you'll get an alert. And the app will show the speed, the intensity, the impacts per minute, and then a diagram of where those impacts are on the bid. So you'll know exactly what's going on. You can actually go online. It's called the Smartress, and you can watch a video of how they build it and then what the app looks like. Well, you know, dying is damn depressing, right? I mean, it's enough to make you want to start drinking even though it's only 1:45 in the day. Well, this one gentleman says, you know, at funerals, you should drink, right? I mean, it seems like it would be poor taste, but he thinks it would be good. So what he did is he has designed for himself a double-lidded coffin so that at the funeral, they open up the first lid and it's all lined up with whiskey shots. So everyone can have, quote, a last drink on him. All right. So those are some of the really interesting new developments in the estate planning area. But unfortunately, I'm relegated to talking to you about recent Texas cases dealing with intestacy, wills, estate administration, trusts, and other estate planning areas. Now, there's a lot more cases in your materials than I'm going to have time to talk to you about. So what I'm going to do is I'm going to focus on the most important and the most interesting. And of course, as we discuss each case, pay attention to the moral, the lesson that we learn so we can avoid litigation and the frustration of our client's intent. We start first with cases dealing with intestacy. And those of you that have heard me speak about cases before usually know my little drill. I say, you know, although most Texans die intestate, there's no cases this year. Well, this year there is one, and it is a very interesting case. It's the Beyer case out of Houston. And what happened in this case is after this person died intestate, this gentleman claimed that he was the intestate's sole heir as his adopted by estoppel son, sort of like someone wished they were for Prince. Now, the trial court rejected the claim. Now, this guy and the dead guy had a very close father-son relationship for not 10, not 20, but over 30 years. And there was no doubt they had a relationship just like father-son. But both the appellate and trial court said, no, this is not an adoption by estoppel because all of the events arose after he was 18 years old. And since all of the acts, all they're getting together and knowing each other for all these 30 years, it all began back in time. When he was over 18, there could be no adoption by estoppel because the court held an adult cannot be adopted by estoppel. We now move to cases dealing with wills. And the first two cases we're going to look at deal with testamentary capacity. The first is the Estate of Kuntz case out of San Antonio. We have here a beneficiary of a prior will, and he attempted to show that the testator lacked capacity when he executed a new will that, didn't name him as beneficiary anymore. So what the trial court did is the trial court looked at the will and just gave a summary judgment that the new will was valid. They just said, oh, well, yeah, new will's valid, summary judgment. And the appellate court reversed. The appellate court said, no, wait a minute. There was more than enough evidence of lack of capacity to justify this going to a regular trial. And here were the types of evidence that the trial court rejected. In other words, the trial court said this evidence wasn't good enough to go to the jury about capacity. He was claiming that his wife, to whom he had been married for over 50 years, was out having an affair. He would try to lease property he no longer owned. He had bipolar disorder, and he had attempted suicide. And the court said all those factors together was enough to raise a fact question, and therefore summary judgment was inappropriate because there was, quote, more than a scintilla of evidence to raise a genuine issue of material fact with regard to his testamentary capacity. Now, the second testamentary capacity case is Texas Capital Bank out of Dallas. And here, the trial court said, yes, the person lacks capacity. And the appellate court had a look at the evidence. And the deal with the evidence is that it was very conflicting. The court goes on, you should see this opinion. It's like 20 pages long. And they go through all the evidence of all these people, family members, people that were at the ceremony, doctors. I mean, it just goes on evaluating the evidence. And the evidence had some people saying, this person has no capacity. They don't know what they're doing. And other testimony said, oh, he was totally with it. He knew exactly what he was doing. So the evidence of capacity was in huge conflict. And the court said, yes, there is, quote, unquestionably conflicting evidence about his intent. But we can't overrule the finding of lack of capacity just because there's conflicting evidence, because that's what the jury was for. The jury heard both sides, and they made the decision. And there would have been plenty of evidence, basically, to support a finding either way. But since the court found lack of capacity, the appellate court said the evidence was sufficient to support the jury verdict. And we learned from that case that it will be very difficult to overturn a jury verdict that someone lacked capacity. Now, the next three cases we're going to look at deal with will formalities. And you're probably thinking, where would there be a problem there? It's not like will formalities in Texas is rocket science. But there's three cases in the last year, appellate cases, dealing with people messing up formalities. And I got to tell you about this first case, because this first case is just one of those things that you would never imagine could happen to you if you were in practice. It's the in-estate of Romo case out of El Paso. And we got these will contestants. And they're putting on this big battle for the will contest. And they're claiming lack of capacity, and if the person had capacity, undue influence. So they're putting on all the witnesses here to talk about capacity and undue influence. And then one witness gets up on the stand, and the witness on the stand was a witness to the will, was one of the witnesses to the will. And just randomly, in the witness's testimony, the witness says, yeah, you know, when I attested to the will, the testator wasn't in the room. You all know that attestation has to take place in the presence of the testator. And so this is like, for the contestant, manna from heaven, right? That we just have a witness that said, yeah, when I witnessed the will, testator wasn't in the room. And we know right away, will's no good. The contestant jumps up and down, all excited. Directed verdict. I needs me a directed verdict. And the judge says, yeah, you're right. Will's not valid. Who cares about capacity or undue influence? You don't even meet the requirements of a will in the first place. Well, the will proponent was real mad and appealed and said, look, they were contesting the will on lack of capacity and undue influence. They didn't contest on lack of formalities, and therefore can't set aside the will for failing to meet the requirements of a will. And the appellate court said, nah, you're wrong. We can't admit any kind of will that doesn't meet the requirements. And it doesn't matter that they were not contesting the will on failure to meet will requirements. Once it was discovered that the will did not meet the will requirements, it was perfectly permissible for us to grant, for the trial court to grant, a directed verdict. Can you just imagine that? You're contesting a will, and all of a sudden that just testimony comes out like that. I mean, it's just awesome. All right. Our next case is the Lemus case out of San Antonio. We had something here that was happening, had two things you shouldn't do. Lay people drafting a holographic will, and then lay people drafting a joint holographic will. I mean, as my students will remember me saying about joint wills, if you do it, I will come and haunt you. There is never a good reason to do a joint will. And so they had a holographic joint will. And what happened is only one hand wrote it. They both signed. But when the one that signed but didn't handwrite it died, they tried to get it admitted as a holographic will. And the court said, no, you can't do that because it's not in your handwriting. Holographic means in the handwriting of the dead person, not the living person of a joint will. And therefore the court said, nope, that will fails. It needed two witnesses. It didn't have it. And therefore the person dies intestate. Now our last formality case is the matter of Cam case out of El Paso. And this is an example of a bad will execution ceremony, not done by a lawyer. So the person decided he wanted to write a will, so he decided the place to go was to the UPS store. So he goes to the UPS store and he finds a notary and he executes the will in front of a notary. Now there's no witnesses on it yet. No witnesses yet. And later he gets two people to witness the will. But one of the witnesses says, yes, when I witnessed the will, he was in the room. And the other witness says, no, not me. When I witnessed the room, I don't know where the testator was, but the testator wasn't with me. So we know at the top that those weren't two witnesses, only one. But we were saved because the court said the notary could serve as a witness, that the notary did sign the will, and that was good enough. So we had the notary, and we had one of the two witnesses, so the witness was good. So the contestant was like all upset, because they thought, now that I have a witness, that they didn't attest in the testator's presence, that would be enough to make the will invalid. But they got, short-circuited because the notary was a good enough witness. And so now the contestant tried to come up with other reasons why the will should be invalid. Listen to these. To make a will, this is the contestant saying, for a will to be valid, the witnesses need to be able to describe all of the will provisions. And the appellate court said, no, that's not there. Then they said, the testator needs to sign the will in the presence of the witnesses. And the court said, there are some states where that's true. Yeah, that's true in some states. But we don't have that here. All that we have here is that the witnesses must attest in the testator's presence. We have no requirement that the testator sign in the witness's presence. So that one failed. And then the next one, the contestant said, I got one more. When the witnesses signed, they didn't have no long conversations with the testator. And they said the testator should speak at length with the witnesses before they attest. And the court said, where does that come from? So they didn't go for that either. So what we've learned here, if you look at some of these cases together, is that a court will be unforgiving if you don't satisfy the formalities. Because unlike a few states, Texas does not have a substantial compliance rule that if you meet the formalities and you're kind of close, that we can forgive harmless errors. We don't have anything like that. We still have a strict compliance standard. On the other hand, the court's not going to impose any new rules. They're not going to impose any new requirements for a valid will. They're just going to stick with the ones that the statute provides. All right. Our next group of cases deals with will interpretation and construction. There's 3 of them in your materials, but we're only going to talk about 2 of them. The first one is the estate of Rhodes case out of Fort Worth. Don't really need to know the facts in detail of this one because it just stands for the proposition that even though the will has not yet been admitted to probate, the court can still do will interpretation and construction. Even though the will has been proposed, filed for probate, that the court could still actually do an interpretation of that document, even though it has not yet been admitted to probate. And the appellate court said, yeah, that's perfectly permissible. Now, the next case is more interesting. And it is, for this year, the only case from the Texas Supreme Court we're going to look at. It's the Stevens case decided last year. Now, it's quite a tragic fact pattern. The husband decided he didn't want to be married anymore. And instead of the long process of getting a divorce, he decided he would just shoot his wife. So he shot his wife died, and then he said, man, I made a mistake. This is going to make my life hell. And so he shot himself. But the problem is, in this case, is he didn't die right away. Not a good shot. So, he killed his wife right away, but for him, he missed a little bit. So he lingered. And the deal was that each will provided for legacies to 9 people if husband and wife died in a common disaster. In a common disaster. And the question was whether this murder-suicide, when the suicide took a long time before the person died, whether or not that would be a common disaster. And the trial court said, you bet it is. Trial court said, yeah, that's a common disaster. And the appellate court said, yeah, trial court, right. They said, look, it's irrelevant to the classification of this as a common disaster that the wife, quote, the husband did not successfully kill himself immediately. And they said, he only lived 2 hours. That's close enough. Then it went to the Supreme Court of Texas. Now, the Supreme Court of Texas issued an opinion. Before I tell you what they said, the first thing they said is, this is so easy, we're not even going to listen to oral arguments. They just said, oral arguments, not going to do it. There is no doubt, there's nothing anybody could say that could change our opinion. So they did not give the parties even the opportunity to present oral arguments. They just said, this is no common disaster. So it's not a common disaster. They said the definition of common disaster in the law is clear. Common disaster means you don't know who died first. That's what common disaster means, when there is no evidence to support who died first. In this case, there is absolutely no doubt. We know who died first and who died second. And therefore, those legacies would not take effect because they did not die in a common disaster. So that's a very interesting case that our Texas Supreme Court decided. Now, the next case we're going to deal with deals with a lost will. It is the Woods case out of Houston. And what happened is, after the decedent's death, his 2 children were declared to be his sole heirs, because there was no will. Well, the 2 heirs decided they didn't want the property. A lot of heirs, they don't want property, they want money. So they sold the land, got the money, thought life was copacetic. Later, the stepchildren found a will. And in the will that the stepchildren found, the property was left to the 2 biological children and the 2 stepchildren, 25% to each. And they went to court, and they said, we got the will. And the court said, yeah, that sounds good to me. And they admitted it as a muniment of title. And they then granted a bill of review, setting aside the determination of heirship. And they said, oh, that was all wrong. We shouldn't have done that. No determination of heirship here because there's a will. Well, that got appealed. And the first the court did was look at whether or not it was proper to grant a bill of review. And it was within the 2-year period, so we don't have a timing issue here. And the court said, yeah, there really is a substantial error with the original judgment. The original judgment said he died intestate, and he died with a will. That's a big error. So that is sufficient to justify the bill of review. Then, they didn't have no original will. I may have left that out before. They didn't have an original will. They only had a copy. And if you have a copy, you got to come up with evidence of why you can't find the original. And they said, you know, the decedent's house was totally destroyed by Hurricane Ike and the flooding. And that's a real good reason to show why you can't find the original will, because it was destroyed in a hurricane. And the court said, yeah, that's a good reason, so admitting that copy is fine. So the property ended up going to the 4 children, 2 bios and 2 stepkids, instead of just the 2 biological kids. Now, you all may think, well, that sounds good, but you forgot what happened earlier. What happened earlier? What did the 2 biological kids that were heirs do? They sold it to a purchaser. And the court doesn't think it right to even talk about what happened to that poor purchaser. Right? I mean, that's the person who's really getting it bad here. What happens? And the court doesn't talk about it. Were they a bona fide purchaser? Do they take the whole property, and it's up to the 2 stepchildren to get their share of the proceeds back from the 2 biological children? What about title insurance? Would title insurance cover the purchaser's loss of, in this case, 50%? Right, because they really did have 50% to sell. So the purchaser did get 50% for sure, but what about that other 50%? Would title insurance cover it? Court didn't talk about that. And then after this case, are the title insurance companies going to say, we're not doing this. We're not going to insure anything that comes from an heir until at least 2 years runs, so that there's no bill of review that might cause us a problem. Because in this case, at least the heirs owned half. Right? At least they actually owned half. What if the will had left it all to a charity or left it all to you? Then the title company might be on the hook for the entire amount. I don't have the answers to any of those questions because the court just doesn't address the poor purchaser, the person who's really aggrieved by all of this. The court doesn't talk about them. All right. Now we look at cases dealing with will contests. And, will contests are relatively rare. Very few wills are contested, but boy, they get a lot of PR and they get a lot of litigation. So we got 3 will contest cases to look at. The first is the Merrick case out of Austin. What happened in this case is the testator's will just disinherited his daughter. And the court admitted the will to probate, and then the daughter contested the will on a ground I have never seen alleged before. The daughter said, look, my dad disinherited me to get even at me. He disinherited me to get vengeance upon me because while he was still alive, I confronted him about the fact that I was sexually abused by him decades earlier. And that because I brought that up to him trying to get closure in my life, he decided that he was going to disinherit me, and that would be against public policy to allow someone to do that. And both the trial court and the appellate court said, that's kind of novel, but that's not a ground. He can disinherit you for any reason he likes. He could say, I don't like the length of your hair. I don't like the earrings that you wear. You don't need any kind of good reason to disinherit an heir. And the court says, an heir has no right to anything. They don't have any right to the property, and the will is free to disinherit them for any reason they want. You can't put an illegal condition on a gift. You can't say, oh, you will inherit all my money if you go kill your uncle. That obviously is against public policy, and that wouldn't work. But you can disinherit someone for any reason, just or unjust, that you want. So that was an interesting case. Now the next case is the in re estate Paramore case. This is out of Houston. And this is another one of them lay people deals. Husband and wife got on the computer, and they were using one of them computer programs to draft up their will. And in there, he made a provision disinheriting his 2 children. And shortly after doing that, most likely because, this is not real, I'm making this part up, but most likely because of the fact that he disinherited his 2 kids 3 days after writing up this will, he had a stroke. And then he went into the hospital for 11 days, and he got discharged, and he decided, man, something happened to me. I need to get this will done. So instead of just taking the will and having a regular execution ceremony, he decided it was time to party. So he held a will execution party. He had family members and guests come, and there was drinking and shooting pool and all sorts of stuff. And he signed the will and was witnessed in all of that. And then afterwards, he got much better. He actually was able to drive again. He continued therapy. He even went back to work. So he had a pretty good recovery. But then later on, he died. And the 2 children that were disinherited said, oh, he lacked intent, he lacked capacity, and he was under his wife's undue influence. All of that. And the court looked at the evidence and said, both the appellate court and the trial court looked at the evidence and said, no, there is plenty of evidence here that he was in good shape. And therefore, there was no ground to set it aside. They had all the people at the party. All the people at the party testified that he knew what he was doing and having a good time there. So, what do you learn from there? Well, you learn that if you do have a client that has had some sort of medical condition, that's going to cause an enhanced chance of a will contest. Maybe you need to take some special steps to preserve evidence to make sure that the will can withstand the will contest. And of course, don't go using the computer, your own will, go to someone who knows what they're doing to prepare your estate plan. All right. Now, our next will contest case is matter of Cam, that case coming up again. This is on undue influence this time. What happened is that the daughter tried to admit the father's will to probate. The son, her brother, objected because he was totally excluded. That makes good sense. And he objected on the ground of undue influence and was able to convince the trial court that was indeed a good ground to contest the will. But when the appellate court examined it, the appellate court reversed, and they said, showing means, motive, and opportunity are not enough to show undue influence. There was plenty of evidence to show that the father was strong-willed, mentally sharp, drove his own car, and lived by himself, lived independently, and that you can't use evidence of excluding one child as being evidence that you're being unduly influenced. That is something you could just do on your own. Here's an analogy. You're in the store, you are shopping, and they get you for shoplifting. And you say, I didn't take anything. And they tell you, well, you have pockets and you have hands, and therefore you could do it. Just like undue influence, just because you have the ability to do it, just because you could have exerted undue influence over someone, doesn't mean that you go evil and use that power. Now, the last wills case we're going to look at may be last in our list, but it is definitely not last in importance. It's the Anderson versus Archer case out of Austin. And in this case, there was a big litigation about whether or not the defendant tortiously interfered with the plaintiff's inheritance right. And the jury said, you betcha, you bet there was tortious interference, and awarded $2.5 million. Yeah, $2.5 million in damages. And when it went up to the appellate court said, you know, even though there's been cases in Texas jurisprudence for about 30 years that have applied the law of tortious interference with inheritance rights, we've realized that there's no case of the that is that. And since there's no Texas Supreme Court case, and there's not really a statute somewhere that makes it a tort either, we don't have it. And we have to wait for the Supreme Court of Texas, or the Texas legislature, to actually authorize the tort. And they ignored language. There's language in the estates code that says certain behavior is not tortious interference with inheritance rights. And the court said, well, that doesn't make any difference. That doesn't mean we recognize it just because they say something isn't it. And then the court talked about that what the plaintiffs were trying to get here was not the money. They had already recovered all the property that they had lost, but they wanted their attorney's fees, and that they were using the tortious interference with inheritance rights cause of action in an attempt to shift attorney's fees to them. Well, so that's what the court said. Now, that case petition has been filed, but what you have to pay attention to is an older case, one that was decided in 2015, the case of Jackson Walker versus Kinsel. In that case, very similar set of facts, where the appellate court said Texas does not recognize the tort of tortious interference with inheritance rights because there's no Supreme Court case or statute. And this one, just on December 23rd of last year, the Supreme Court granted petition on it. So this is going to be a highly significant case, because this is going to decide whether Texas does or does not recognize the tort of tortious interference with inheritance rights. Litigators across the state are on edge to see exactly how this case will come out. So we'll have to wait until next year to see what happens. Maybe they'll get to it by next year. One never knows. So that finishes up our wills cases. Now let's look at some estate administration cases. We'll start with a simple one, the venue case of In Re Estate of Davidson, which stands for the proposition that an estate debtor lacks standing to request a court to transfer a probate proceeding from a county of improper venue to a county of proper venue. A debtor of the estate is not an interested party. Creditors are interested parties, but not debtors according to our estates code definition. The next case is a case dealing with appeals. It's the estate of Davidson case out of Dallas, and it stands for a proposition which I think you would all have agreed with anyways, and that is, if you have a judgment that removes an executor or administrator from office, that is a final judgment, and therefore it can be appealed. Our next case deals with immuniment of title, the In Re Jackie case out of Houston. Now, what happened here to start with is a will is admitted to probate as immuniment of title. No problem, everything's copacetic. After 3.5 years goes by, the court reopened the estate and appointed an independent executor. Now, why did they do that? Well, new evidence came up that they needed an executor to pursue claims due to the estate. In other words, money was owed to the estate, but they needed an executor to go do that. Yes, it would be very inconvenient or cumbersome for the beneficiaries, who now are actually the owner of that right, to go do it. And they said, well, get an executor to do it, and they can handle it. And the appellate court, remember, the trial court bought this, yeah. The trial court said, just fine, they appointed the independent executor to handle it, great. And the appellate court said, you bad. So they conditionally granted mandamus, slapped that judge in the face, and said, hey, you better dismiss that or we're going to issue mandamus on you because you went way beyond your power. You don't have the power to do that nonsense. The muniment of title order, the time to appeal had long gone. The time to get a bill of review expired after 2 years, so you can't do that. So you didn't have any power at all to appoint to open an administration and appoint that independent executor. Now, the last estate administration case we're going to look at deals with attorney fees, the matter of Cam case out of El Paso. This is the third time we've looked at this case. Now, what happened here is that the will applicant, the proponent of the will, who got the will successfully admitted to probate, wanted to get reasonable attorney fees from the estate. That sounds normal. But the other side said, she was in bad faith in getting that will admitted to probate, and therefore can't get her attorney fees, because the statute requires that if you try to get the will admitted to probate, you have to do so in good faith with just cause. And the court said, that's for someone who is not successful in getting the will admitted to probate. This person got it admitted to. How could anybody be in bad faith in getting a valid will admitted to probate? And so the court said that the will proponent was indeed entitled to the attorney fees. Now we take a look at trusts. And the first trust case reminds me of Amazon Web Services. Did you all hear what happened with Amazon Web Services yesterday or the day before? Some of you are nodding, because a whole bunch of websites, thousands of them I think, went down because of something wrong with Amazon Web Services, which is used by hundreds of thousands probably of websites. And what happened, they just read it in the paper this morning, is that somebody made a typographical error. They typed in a code that was supposed to shut down like 1 or 2 servers, and it ended up shutting down a whole bunch of them. Just a typographical error. That's what this case demonstrates. U.S. Bank, a case out of Fort Worth. Complicated set of facts, actually. The beneficiary sued the trustee. A foreign corporation received a no answer default judgment. The trustee appealed. The appellate court examined the pleadings and determined that the trial court lacked personal judgment over the trustee because the beneficiary's service of process was invalid because they did not allege proper jurisdictional facts because they miscited the section of the estates code. The concurring opinion makes it real clear. The concurring opinion says, look, the only reason it's wrong is whatever drone typed in the section of the estates code, they typed some of the numbers wrong. So we learned from that case this simple moral: when you do something, like proofread it really carefully to make sure it is right. You don't want to shut down your case or the web servers. Now our next case is the Texas Capital Bank case, which tells you a point which you all should know, but in this case, the people kind of didn't remember it. We all know. Is a trust a legal entity? No. A trust is what? A piece of property. A trust is not alive like a corporation is, right? So you cannot sue a trust, and a trust cannot sue. You have to sue the trustee in the trustee's representative capacity. Well, in this case, the person attempted to sue the trust as an entity. And therefore it didn't work. Now, I can tell you what they were thinking. I can tell you what was in the attorney's mind, because that same entity had been properly served as the executor. They had been served in their capacity as an executor, but not separately in their capacity as a trustee. And the court said, it doesn't matter that it's the same human. Doesn't matter that it's the same person or entity. I think it was a bank. But it doesn't matter that it's the same entity. You need to serve them in each capacity separately because they are separate capacities. Now, the next case we want to deal with deals with a lost trust instrument. Now, many of you are very familiar, I'm sure, with our lost will statute. We talked about it a little while ago in a case. If you can't find the original will, you can rebut the presumption that arises of revocation when you cannot find the original, and you have to prove what the will said and some facts to prove why you can't find it. Like in our case, it was the destruction from Hurricane Ike. But we don't have in Texas a lost trust statute. We don't have any established or codified way to prove a lost trust. And in this case, they were trying to prove a lost trust instrument. And the court said, look, just because you can't find the trust instrument doesn't render the trust ineffective, as long as you have sufficient evidence to prove what the contents were. And they had plenty of that evidence in this case. In fact, this is kind of funny. The person who was now claiming there was no trust had in a prior case under oath sworn to all the terms of the trust, but now was saying no trust. And they said, well, you know, there's also some judicial estoppel there that's going to keep her from claiming there's no trust. She already testified to all the terms of the trust under oath in a prior action. The last trust case we want to look at deals with receivers, the estate of Hoskins case out of Corpus Christi. This is dealing with an estate that has been in litigation for over 30 years. That's how long the litigation has been going on. And the court said, well, we got to get a handle on this. And you know what we're going to do? We're going to appoint a receiver. And the receiver can come in and try to make some sense out of this. And some of the parties got upset and they appealed. And they said, hey, receivership is an extreme remedy. And just because we've had litigation for 30 years, that is not extreme enough to justify the appointment of a receiver. And the court said, yeah, it is. They said, yeah, that's it. And they said, look, when this receiver was appointed, they weren't even appointed like sometimes receivers are to swoop in and grab all the assets away from the trustees and manage it. All that was here is they were going to do some accounting. They said it really was more just appointing a court-appointed auditor to try to see what was going on. And so now we come to our last case for today, the Wise case, dealing with a power of attorney. This case came out of Dallas. We had a grandmother who was the principal of a durable power of attorney, but before the power of attorney kicked in, she transferred land to her grandson, keeping, though, a life estate, the authority to sell, and the power to change the remainder owners. Later, the agent, under a valid durable power of attorney, entered into a contract to sell the land and then filed a deed, in effect, revoking the original deed that the principal had filed. Then the principal, unfortunately, lost capacity and had to get a guardian, and the agent, the same person, was appointed as the principal's guardian. But now, since they were a guardian, they had to go to court to get permission to sell the property. And they went to court, and they were just about to get permission. And so now, the agent got appointed as the principal's executor and still wanted to go through with the sale. And there was a big dispute now between the grandson who was hoping to get it and the agent who says, look, I've already entered into a contract to sell it, and that money now becomes part of the estate to be handled however the estate was. And both the trial court and the appellate court said that the agent prevailed and that the agent had proper authority under a power of attorney. It was kind of a strange durable power because it was not in the normal statutory form, but the court said, the form was good enough and had granted the agent the authority to sell that property. It will be very interesting to see because these retained life estate deeds and all of that may now become less common now that our last session has authorized the transfer on death deeds. We already know that an agent cannot create a transfer on death deed, but could they revoke one that is already existing? I'm not sure our statute yet addresses that. Well, anyways, my time is up. I hope that our time together has been helpful, bringing you up to date to what our courts have been up to, and that you can use the lessons you've learned from these cases to do a better job in your practice and for your clients. Thank you.
Thank you, Professor Beyer. Our next speaker will be Christopher Rhodes. Chris grew up in Cypress, Texas. He is a graduate of Baylor University, where he majored in political science with a minor in criminal justice. Chris will be presenting his article that will be featured in Volume 9, Book 2 of the EPJ, titled "Who Gets the Dog When the Marriage Gets Rough? Complications Arising from the Classification of Family Pets as Traditional Property." Chris is a 2L staff editor on the EPJ, and please help me welcome him to the stage. Chris?
Thanks, Amanda. Well, as she said, I've spent the past couple months researching particularly complications that arise from the classification of family pets as traditional property, specifically as this applies to divorce proceedings. So I'm willing to bet that it's not much of a stretch that many of you in the audience have a pet yourself, and many of you would consider that pet a member of your family rather than a piece of your personal property. However, the law strictly views it as personal property, and that's where I believe there is a disconnect in the way that we view our pets and the way that the law views our pets. And since the way that society has shifted in its way that it views its pets, now we have them as for companionship rather than for food or clothing and the likes like that, I believe the law should shift as well. And I believe this is a very pervasive issue because 1 out of every 2 homes now own a household pet. And with divorce rates hovering at almost 1 out of every 5 marriages, this will most likely continue to be a prevalent issue. I began by tracing the property status of pets, and originally all pets and animals alike were animals feri naturae, or just wild animals, and nobody had any ownership claim to these animals. Next, courts began to explore granting a conditional property status to pets if certain criteria and factors were met. These factors were, we need to have the pet assessed, affix a set value to the pet, and add the pet to a registry. If all these factors were met, the court would consider granting a property status to this animal. Now, however, as you know, all animals are considered property. Why is this a problem as it concerns divorce proceedings? Well, as I said earlier, I believe this approach is very antiquated as our shift in the purpose of pet ownership has changed. Also, the market value of these animals is often very unascertainable or low, or you could argue that it's also negative because the maintenance of the pet also costs upwards of $1,000 per year. There are exceptions though for things like guide dogs, show dogs, the likes like that. And furthermore, we've already acknowledged that pets are a unique form of property through passage of animal cruelty laws and stuff like that. There's no other form of property that we grant specialized exceptions for except for animals. So courts need to acknowledge their already unique property status. Furthermore, equitable distribution and community property distribution judgments are final. Why this is a problem is, consider the court awards ownership of the pet to one spouse, but then that spouse begins to neglect the pet. The court is powerless to go back and change their judgment. So there are 4 approaches when dealing with this. We have the traditional strict property approach, and there are also 3 other approaches that courts have fashioned themselves because they're basically, they don't feel comfortable applying this approach anymore because it's so outdated and so antiquated. And as I said earlier, the strict property approach is just that. They treat a pet just like any other piece of property, like a table or a chair. People argue for maintenance or for maintaining this standard, though, because they say basically modern property division principles have been carefully crafted and refined by courts and legislatures over many decades. And basically, why try to change something that isn't broken? First, we have the best interest of the pet standard. This approach was fashioned off of the Uniform Marriage and Divorce Act of 1970. Basically, what this does is it analogizes pets and children. It takes certain factors from the Uniform Marriage and Divorce Act and applies them to pets. With the first factor being the quality of the pre-existing relationship between each disputing party and the pet. Secondly, the stability of the home environment where the pet would reside. And third, which party has been the primary caretaker of the pet. All of these will be used as evaluative criteria when determining which spouse would get ownership of the pet. The second standard is the best for all concerned standard. This standard considers intangible subjective factors such as the pet's general well-being and any special relationship that may exist between the pet and the pet owner. What this does is it takes the previous approach and builds on it. Basically, the first factor of this approach is the previous approach, just in factor form. So factor 1 being, why would the pet better thrive, live, prosper, love, and be loved with one spouse as opposed to the other? This is the previous approach in factor form. The second factor being, why one spouse would benefit more from having the pet in their life as opposed to the other. So this approach not only takes into account what is in the best interest of each pet, but also what's in the best interest of the spouses. This standard, like the previous one, grants full ownership to one spouse at the complete exclusion of the other and does not consider any sort of custody agreement. Which brings me to custody agreements for pets. The hallmark attribute of custody agreements for pets is, that it doesn't preclude ownership of one spouse. And this is most advantageous to apply when both spouses are similarly situated and would both likely provide good care to the pet. This allows the courts to avoid from having to make difficult decisions of awarding full ownership to only 2 spouses, when there are 2 loving spouses. However, this approach does have the strongest counter-arguments, being that custody agreements are often very long and drag on for years. They also often burden and hinder the court system, and they argue that this could be a detriment to child custody cases. As acknowledgement of how prevalent this issue actually is, Alaska actually amended its statutory code on January 17th of this year, which basically outright forbid the strict property analysis as it applies to divorce proceedings. What this amendment to the Alaskan statutory code did was explicitly forbid judges from treating pets as traditional property in divorce proceedings, and now it requires courts to take into consideration what would be in the best interest of the pet. And even empowers them to grant joint legal custody to divorcing spouses. However, what it doesn't do is define what best interest of the pet actually is. It doesn't list any factors, and this is going to leave the door wide open to judicial discretion, which I believe could be a possible problem in the near future. My proposal was amending Section 7002 of the Texas Family Code. What this section does is it provides for division and disposition of certain property under special circumstances. So Texas already has a section that provides for disposition of certain property under special circumstances, and I believe that pets should be included in this section. It's the perfect spot for it. Basically, here, this is also in your materials. I know this is probably difficult to read, but this is my proposed amendment, and basically what this is codification of the best for all concerned standard. And unlike the Alaskan amendment, I actually listed the evaluative criteria, so it leaves less to judicial discretion. So overall, pets are not just things anymore, that they occupy a place somewhere in between a person and a piece of personal property. And I believe that it's time that we acknowledge that we have these sections like this, and we need to put them to good use, because doing so would truly be what's in the best interest of our family members or our pets. Thanks.
Okay, before we adjourn for our next break, Southwest is going to have another raffle, so I'm going to have Chris pick a card here where he's going to win. Remember, you have to be present to win. Andy Icock? Is he here? Andy? Not here? Okay. Keith Thompson? Perfect. Just stop by the Southwest table. We will adjourn for 10 minutes. Thank you. You did.
Two-thirds of the battery still. Okay.